Hi there, good afternoon, everybody. I see that we've got some folk kind of entering the room just now, so thank you for making it along and making it on time. We'll give another sort of minute just to kind of let the rest of the folk make their way through today. But thank you so much for joining us this afternoon. We've got a really interesting and pretty packed conversation ahead of us. So please be prepared to share your questions for our panelists in the Q&A panel in the chat function. As you're no doubt aware, we are recording this session, and the recording will be available after the session's over. And yeah, we will be having a Q&A at the end of the session, about sort of 15-20 minutes before the end. So please be sure to get your questions into the question and answer function in the chat. Okay. So thank you so much, everybody, for joining today. Before we dive into today's session, I would like to thank the Data Lab community for hosting this event. So the Data Lab community brings together data and AI enthusiasts from around the world. And this online hub provides a collaborative space for connection and growth and learning, with a thriving community of over 7,000 members. If you're not currently a member of the Data Lab community, then please do consider joining. We're sharing the link in the chat, and you can join up and engage with the community members from all across the world. And one more wee plug before we dive into the actual meat of the session. So at the Scottish AI Playbook, which is the Scottish AI Alliance's programme for supporting SMEs to adopt ethical AI, we're looking for feedback from users from across all sectors and all different types of users to help us shape the next phase of the playbook's development. So please take 5 minutes after the webinar, not now, but please take 5 minutes to complete our survey, which we will share in the chat. And your responses will be used to help shape the future development of the playbook and of the resources that we develop as well. So it's a great opportunity to get involved with that. Okie dokie, so all plugs and self-promotion over. I am so happy to kind of move on to the main part of our session. And as we all know, the world of AI regulation and intellectual property challenges relating to AI is rapidly unfolding, with accelerating capabilities in AI throwing up questions about ownership, compliance, and risk. So I'm therefore delighted to welcome our two expert panelists today, both working at the forefront of AI, law, and innovation. So first up, we have Linzi Penman, who is head of DLA Piper's UK technology sector. A technology, data, and AI lawyer. Linzi advises international private and public companies on matters relating to IT, commercial and compliance issues. And she has a particular focus on financial services, consumer goods, retail, media, and entertainment sectors, which I think might be most sectors. And we also have Jess Davis, a chartered UK and European patent attorney at Lawrie IP. Jess works in the firm's electrical and mechanical patents team, where she has extensive experience across fields including AI-based inventions, software, medical devices, nuclear engineering, sensor systems, optical systems, microelectrical mechanical systems, mechanical engineering, and semiconductor device electronics. So you are in excellent hands today with our panelists. So please feel free to make the most of them being here and ask some questions. So we're going to kick off. Linzi, can you please give us a bit of a brief overview about the current regulatory landscape for AI in the UK at the moment, and particularly the impact that the EU AI Act has on how we regulate AI, and whether we can expect any further changes there? Give us a bit of a baseline for the non-experts in the room.
Yes, delighted to. It's been a very fast evolving space, this, so I wouldn't be sort of nervous if you're struggling to keep up with the pace of change because the regulations are coming fast and thick. But if I take a little bit of a step back, the EU AI Act, so some of its provisions are already in force. We have some more provisions coming into force in August, and then it's a bit of a staggered implementation thereafter. And I'd say for the last 6 months or so, one of the common questions we've had is, okay, we know about this law in the EU. How does it impact us in the UK? So I thought I might start there. And there's sort of three triggers where it would apply to you. And that's if you're making an AI system available in the union. And so that will actually take out quite a lot of specifically Scottish or domestic companies. Likewise, if you're putting into service, so basically if you're supplying something directly to someone, again in the EU market, so that might not bite. But unfortunately, and here's some free legal advice, which lots of companies have spent thousands of pounds trying to navigate if they can sit outside it and avoid it. Basically, if you're making output that's produced by an AI system available in the EU, or if you're using something in the EU. And so just to put that into context, a lot of people are using these systems in the HR field, whether it's to sort of summarize meetings or whether it's to help streamline recruitment decisions. If that would then touch on employees there, or if you're using it to create customer segments, profiling, and then you're going to be using it to influence your marketing decisions to people in the EU, then you will be caught. So that third limb is super broad, intentionally so. So, I guess heads up, you should be aware of that. But where are we in the UK? It's a little bit uncertain, which actually I think is a bit of a challenge for some organizations. And I know that, we've seen it with the data protection landscape itself, that our government's trying to be more pro-innovative and they're trying to relax certain requirements. But actually, it just seems to be quite difficult for the bigger organizations to then navigate that because they want to have we use this phrase like local, you want to be compliant locally, but have a global mindset. And actually, the more consistent you can be, the easier it is to grow. But where are we? Well, we had a white paper that came out, I think, a couple of years ago now, 2 years ago, 18 months ago. And it said that the UK didn't want to have a sort of, horizontal bit of legislation. You really wanted to have a principles-based framework. So there's like common themes that come through from that. And they thought that would help them keep up to speed with the advances in technology, which you've mentioned, Dawn. But then it doesn't seem to have been enough. So it seems that there's about to be a bit of a pivot. And really, we had an AI regulation bill, which was a private member's bill. And those rarely become law, but they do tend to set the political direction. And they were saying the risks that can come from, you know, unsafe use of these tools. Because obviously, I'm actually a huge advocate for using this to advance. I'm in the tech space and I've seen the way that, technology has transformed businesses for the better over the last, 10, 12 years. But it's without, doing that, setting the landscape to make sure it's safe, that's where they get a bit nervous. So I think we'll expect some more things to come, but we're getting mixed messages here because on one hand,
Yeah.
got, the sort of very prescriptive requirements around chatbots, and we've seen where that's gone really wrong, where we haven't had the right guardrails in place, particularly with those that are more vulnerable, whether that's children or adults. And that's been very prescriptive. But then on the other hand, we've just had a brand new law that just got royal assent the day after my birthday last month, actually. And that's saying that, before we had this concept of you shouldn't be doing automated decision making, which is where the human is not in the loop, to use like a lawyer phrase, unless you had consent, basically, or there was, a legal requirement. So it's quite restrictive. That's come in and actually said in the UK it's a bit more permissive. So as long as you've got safeguards in place, so it's a minefield to put it really bluntly. But we're focusing on commonality. So for companies that have, organizations in the EU, in the US, we are trying to look thematically at like, making sure it's ethical, making sure it's secure, making sure we're complying with the existing principles we know and love about GDPR. So I appreciate that was a bit of a divulge of information, but I think the summary is that there's lots of different laws that we're trying to navigate here, and you have to really consider it quite holistically.
Yeah, no, that's really helpful, and it's given us a good sort of baseline for where we're at. And to be fair, it's also very representative of some of the kind of challenges that we get from businesses and organizations that we engage with. That the landscape is very confusing for the layperson, and kind of changing like all the time. And I think taking that sort of like baseline, like what is ethical, what is inclusive, like how do we like be responsible, can sometimes be the best way to sort of navigate a, a system that is currently sort of firming up the actual kind of regulatory kind of scaffolding for this technology. Jess, I imagine that the international patent system is also maybe in a wee bit of a tizzy because of the kind of rapidly developing nature of AI. So, how is the kind of patent system adapting to this kind of evolution of AI technologies?
I think there's probably less kind of confusion in our patent world because I think we've been aware of AI early on, it being a really technically oriented field. So I would say there's lots of ways that we're changing over time because of AI. Um, in terms of the European patent offices and the UK patent offices kind of attitude to AI. I think that shows up in the fact that they actually use it.
Mhm.
So when you file a patent application for an invention, the patent office where you file that patent application will search your invention and see if it's been disclosed before, just to make sure that it's novel and inventive. And so patent offices, um, the European and the UK at least, they are using AI tools to do this searching. And they'll use their own developed AI tools, but it just goes to show that they are quite open to it, the patent offices. And so, um, even though the patent office was originally set up with much less developed kind of technology, and it didn't have AI inventions in mind, the people who work at the EPO and the UK IPO, they're keen to see technology be recognized and used properly. So the European Patent Office and the UK Patent Office, they're using AI. In terms of whether they're prepared to grant patent applications to AI, that's something that's developing over time. And we're getting, as part of the patent system, the patent offices give guidance of what makes a certain invention patentable. And so we keep getting year on year updated guidance, just because they always, add to that guidance and publish it every year. And we're getting more and more clarity over time of what makes an AI system patentable. And so it tends to be different per patent office what's
Mhm.
considered patentable. In the UK and the and Europe as well, they can be a bit kind of harsher on what they consider technical enough
Mhm.
for a patent to be granted. And we might talk about this more lately, but later. I mean, the requirement for a patent to be granted is that it's novel, inventive, and industrially applicable. But beyond that, you also need to have enough technical character. And
Mhm.
sometimes AI inventions, if they are not sufficiently considered technical, then they might struggle to be granted. And so, what is considered technical? Neither patent office will define the meaning of that word. And so, what they do is they just keep giving us examples of what's
Mhm.
technical, what's not technical. And so, um, for an AI based invention, you're probably looking at something that has a technical effect on a technical process. So solves a problem in a technical way, and that might be something like an AI model that helps identify irregular heartbeats. It's got an actual technical application there. Whereas, say, you've got, an online shopping business that uses AI, that would much more likely struggle to be seen as technical, because that's more towards business methods and AI, which, when they're considered together, don't meet the technical character threshold. So that's kind of what we're looking at mostly at the moment, is considering which patent offices around the world, because they all have their own set of guidelines and rules and articles, which patent offices are going to grant a certain AI invention. So that does develop over time, but I think we're just trying to get more and more clarity on it with the guidance that we get, and each case that comes out. If you are filing a patent application, you argue with the patent office until it's granted, and sometimes those cases go to hearings, and then we find out more information on what's considered technical at those hearings. So patentability, that's something that we're getting more and more information on as we go. So if you ever need to speak to a patent attorney about whether your invention's patentable, they'll have more and more information as time goes on. And then also inventorship is something that's kind of becoming more clear over time when it comes to AI. There were a series of cases going on around the world called the DABUS cases. And that was quite interesting because someone had built an AI tool, and that AI tool had come up with some inventions. And the person who built the tool decided to file for patent applications in the name of the AI tool to see if needed to have a human be the inventor. And so those cases went all the way and were heard in multiple countries. And we've recently had really clear decisions in the UK and in Europe that AI must, AI cannot be an inventor. It must be a human inventor for you to have a patent granted. So that's something that we've found out recently. And then also in the US, they came to the same conclusion. Interestingly, an AI invented patent was granted to the DABUS system in South Africa, but that's because they didn't have a substantive examination system. So things like that kind of go through the cracks slightly, but that was interesting. And then in terms of other ways that, internationally we're adapting to AI, I think Linzi probably sees it too, but a lot of legal firms and IP firms are exploring how they can use AI. So whether it's through making our processes more efficient, helping us draft documents, there will probably be an increase just because it helps keep, the industry competitive, and also allows us as legal professionals to spend more of our time on the actual tough questions that require a lot of thought. So I think legal firms, being careful kind of natured, are kind of tentatively dipping their toes in using AI tools themselves. But it is something that I expect will kind of develop rapidly over the next year.
Yeah, no, that's great, and it's really interesting. I have some experience of assisting in filing patents pre anybody using AI. Back in deepest darkest 2002 or something. But that's really interesting that that you managed to kind of like slip through in the South African office, and just because of the different standards across there. So I'm sure we can expect an uptake from our audience of putting their patents to the South African office. Well, I'm sure they sorted that by now. But that's a really interesting thing that you mentioned about the kind of uptick of legal firms kind of utilising AI, because that is something that we're seeing, and some of the sort of kind of bigger firms, the bigger firms certainly, but some of the bigger firms in Scotland as well. I'm thinking about kind of Thorntons, for example. They are definitely making a concerted effort to kind of utilise AI and stuff, and that's fraught with sort of risks and challenges. And I think that's probably a good opportunity to bounce back to you then, Linzi, and talk about like what are some of the risks that companies should be aware of when they're implementing AI solutions, and how can they mitigate these?
I know, and I think in standards is quite a helpful way to do that. And I know that you guys have been great at really promoting that, particularly some of the ISO standards and making sure that you do like a risk management consistent way of dealing with these kind of things. And that's definitely where I've seen it go wrong with companies is when you don't have an established committee set up with different stakeholders so that someone in the HR department might be analyzing a tool and they're considering it very much with the HR lens, and then someone else might be looking at to help people check their coding from a security perspective. But you're not bringing the lessons learned together. So I think establishing that, and then some of the key risks, a lot of them are things, again, that we're already familiar with, like data privacy, security. It changes the way that, threat actors can get in. So I think it's really looking at that through like a net new lens. So some things are just that it's going to be slightly nuanced. So we might have to adapt our existing InfoSec angles. Other things are completely new. For example, if you're talking about Gen AI, and again, as a sort of, I know we're talking about the risks here, but as something you could immediately take away from this is make sure everyone's aligned on how we're defining AI, because the risks are very different if we're talking about the traditional machine learning techniques that have been around for over 50 years or so versus, really when we're talking about agentic AI and LLMs, etc. So I think the thing around hallucination that people get nervous about is it's actually a feature rather than a fault. So it's, if you think about how it's designed to work and sort of predict the next likely word, for example, part of that it's always going to have an element of random probability. So it's more about what guardrails can you put around that to sort of mitigate the risk. So whether that's training it on your own sort of data sources, if you create like a RAG, a retrieval augmentation generation techniques overlayer, having like a ring-fenced instance again, so that you're sort of minimizing what it might be pulling from, which might be inaccurate, and then really, really properly embedding human in the loop. I think that's one of the key things. So we, as a law firm, and I'm glad you mentioned that, we've obviously been looking at that, and really the mindset that we have is treating the output as you would, someone who's straight out of university who is very, very keen. They're probably not, well, in fact, no, I was going to say probably, they're definitely not as quick as the output you can get from using some of these tools. But, the instructions that you give it very much impact what you get out. That's the exact same as when you're dealing with a junior who's coming new to the business. And then the mistakes they make, I think the difference here is that some of these new Gen AI solutions, it's the confidence with which they will, give these answers back to you. And then the other one that I just wanted to touch on, because when I like to think of risk mitigations, I think of it in 3 tiers. There's the sort of contractual provisions that you can get from the model provider. You might not have very much commercial leverage there, so it might be take or leave it. You've got standardized version. The sort of technical thing. So there's a lot of technical controls and guardrails. Like you can, if you're, building your own interface, you can adapt what prompts people can use. So we've definitely seen that, for example, in the HR space, making sure that if people type in certain buzzwords that would indicate that they're maybe going to use it for a redundancy decision or anything that's linked to performance, you get an error message, can't go any further, you don't get a response. So there's technical things. And then there's the organizational piece, which is, bringing people up to speed. And that technical one I wanted to touch, I don't know if anyone's followed the Air Canada case, and that was where someone was sort of engaging with the chatbot to ask if they could get a refund because they were going to be traveling for a funeral and things were changing around, and it just ran out of information, so it started to make things up. So again, if you can sort of ring fence that from a technical perspective and really bring everyone along on the journey. So it's not just the procurement team who are sort of getting the tech in place, but it's also the InfoSec team and your research and development team, and make sure that everyone's sort of bringing that together. Because those are in my mind, the sort of things that we need to focus on that are net new as a result of this technology.
No, that's fantastic. And yeah, I'm aware of the Air Canada situation. Did the the LLM kind of system not end up telling the customer that they could get like a massive like refund or something like that when they
Yeah.
or something like that? Yeah. Um,
Actually,
which is great for the customer, right? And I think one of the things that's quite heartening is we recently were engaged with Chase Bank around like a AI literacy initiative with some of their apprentices, and actually one of their apprentices the um building out their sort of customer service chatbot system, but in a very sort of like kind of interaction design, service design, like kind of user experience way where they're going through every potential like kind of channel of kind of like how might a person engage with this kind of
yeah.
chatbot and stuff, um, which is like which is entirely the right way to go about it, and they're coordinating a sort of multidisciplinary team in order to be able to do that properly. So yeah,
That's perfect.
yeah,
I felt because the airline there tried to say, well, actually, it's the chatbot that's responsible for its own actions, and sort of similar to what Jess was just outlining from an IP perspective. You know, the court came back and said, no, you are the one that has to make sure that it has sufficient accurate information to give the end user, and you know, ultimately, you're responsible for it. So
yeah, absolutely. And
nice try.
yeah, nice try, nice try. It was worth a try anyway. Yeah, just kind of coming off the back of that in the way that like you've already said that kind of you mean AI can't be an inventor. AI also can't be responsible for the decisions that it makes. Like in a kind of context that way. Are there other sort of like challenges like that's faced in this sort of kind of um protecting or patenting of kind of AI driven innovations that you're seeing coming up um, or see on the horizon perhaps? Oh, you're on mute, Jess.
Thank you.
That'll happen.
That's a good question. There are multiple kind of challenges that come up with AI and IP. The first one being kind of where the IP originates is, can it be owned? Is there an owner here? And because the owner will usually acquire their rights from the creator. So um, typically, if you, in general, with IP, if you make the output, usually you are the first owner, and then you know it may be transferred to your employer or by contract or in some other way. So first of all, you have to establish, can this IP be owned? Is this my IP? So obviously that's under, you know, a lot of scrutiny at the moment when it comes to copyright, for example. Say if you've got a literary, dramatic, musical, artistic piece of work, that typically under normal copyright law, the owner or the human author who created that work is you know the creator, the owner, the author. But then when you have, say, ChatGPT creating that output, does it have an author? That's something that is completely case by case dependent, and you have to take into account the prompts, all of that sort of thing. So just like you can talk about that when it comes to copyright, you can also think, okay, if I'm inventing and I'm using AI to help me brainstorm my ideas for an invention, you know, am I the human inventor here? And
Mhm.
obviously, case by case basis, it will depend on how significant your human contribution is there. Um, so yeah, at the beginning there's that problem, and I guess because we're still in flux at the moment in terms of how we kind of draw the line there, and whether you know copyright laws or even you know other IP laws, whether they're going to evolve in the next few years. The best thing to do is probably just keep you know detailed records of you know generation of these ideas so that you can look back and actually establish you know whether or not there is ownership there. And then when you're thinking about you know say you've got an invention and you're going to patent it, um, you know, making sure you identify human inventors correctly because that's necessary to progress through the patent application process. So pick your human inventors wisely. And if you need to assign IP rights, make sure those assignments are done. And then also, before you file your patent application, at least in the UK and Europe and in many other countries, you shouldn't be disclosing it publicly or making non-confidential disclosures of your idea, because you have to make sure your idea is novel at the point of filing the patent application. So we would want everyone to be careful when inputting their ideas into these AI systems, because, for example, the more kind of publicly available free models might not have any confidentiality obligations to your information. So if you're putting your invention that you've not yet filed a patent application for into ChatGPT, you might be disclosing it in a non-confidential manner, which might impact the validity of any future patents for your idea. So be very careful with that. And make sure.
And I mean, that's happening. Like, we've heard about that happening with them. Like, people coming to us and saying, oh my goodness, we didn't have guardrails for the coders, like the people who have access to our crown jewels, and they wanted to check for vulnerabilities using some of these free tools, and now our code is out there. And, you were saying a lot of the vendors don't have that as a default. It's actually worse than that. They've given themselves permission sometimes to use it to improve their own tools. So I think that's a very, very real risk that you've flagged there, Jess, and something I would be very alert to.
Totally, because even I'm talking about patents here, but then you go to trade secrets where the confidentiality requirements are pretty much eternal. And you're never really safe to disclose that information. So if, some code, companies might want to protect via trade secret route. And so, be very careful, because obviously it sounds really nice to just put your code through a machine and go, please find the bugs. That would be lovely, but be sure that you can trust that the input is confidential and remains confidential. And sometimes when you have purpose-built AI systems, with all those, kind of ring fencing and kind of things in place to protect the information, that is what you need to make sure of if you're going to use anything for confidential information. And then once you're actually preparing a patent application for your AI invention, if you have one, there's a challenge in explaining how it works, because AI can be a bit of a black box when you use it to help you with a technical task in a way that you might want to, protect it as an invention. And so one requirement of a patent application to be in, a grantable kind of position is that you've clearly explained how the invention works. And so that's called sufficiency, to make sure that you've sufficiently explained that, your invention does work and how to make it work. And sometimes when we have clients come to us, they say, we have AI that does this, but they struggle to really explain, the nuts and bolts of it. So I think it's important to, when you're building these systems, make sure you understand them if you'd like to, protect the patent. So that's another challenge. And then sometimes, patent offices will push back a little on AI-based inventions if they, don't see them as technical enough. And your patent attorney should hopefully be in a position to explain to you kind of the level of patentability that your idea might have. And that's really because just putting something into an AI system and taking a task and making AI do the task instead, that intrinsically is not considered technical. You have to have something further. You have to contribute something further that's technical and a further problem that's been solved by your system. So sometimes that can be hard to demonstrate, and patent offices can sometimes be a bit resistant when they see software or AI in an invention. They might want to be a bit overly cautious and try and prevent it going through to grant it. But if you can demonstrate that you've solved a technical problem in a technical way, and it's not just something known that's been, automated through AI, then you should be able to get your patent granted. So I think those are kind of the main risks. There are risks and considerations at every point. But I think, a patent attorney, if you want a patent application filed, should be able to guide you through it from the very beginning.
Yeah, absolutely. No, that's great and really detailed. And it sounds like if you were going to enter into this area, definitely speak to Jess. like, because even I have a law background, and even like I can see like how complex it would be for to work through that system. So I guess kind of coming on from that, and I'm going to stick with you just for a second, Jess, before bouncing back to yourself, Lindsay. Look, so we've kind of spoken about the challenges of, what I mean, patenting like your own like kind of AI kind of innovation and all that sort of thing. But what about the flip side? For the businesses and the organizations out there who are using AI generated content, be that video, be that code, be that images, um, is there a risk, or are there any issues for them utilizing that content that they may be in breach of someone else's IP or patent or kind of rights like that? Is that something that we need to be considerate of when we're kind of using all these lovely outputs that we're getting from these systems?
Yeah, so that we kind of give the general umbrella term of freedom to operate, whether you are free to use, whatever you've created here. And I think that's where it is a bit fuzzy, because if we don't know who owns the output, can we say that, there isn't another owner? And whether that owner, so it depends, obviously. I think it's something that, differs between copyright and then patents. In copyright, it requires, copying to take place. Patents does not require like copying. It doesn't require knowledge of the patented invention. You might just be infringing a patent. Um, even if you don't know it exists. So that's why, say if you're kind of launching a new product that, is inventive itself, or could potentially have been patented in the past, we tend to recommend our clients do freedom to operate searches, which helps them find granted patents or patent applications that have been published that relate to their product, to see if it has already been protected with a patent. So if someone's trying to maybe launch a new system or a new kind of technical product that uses AI, then I would say approach an IP attorney, a patent attorney, for a freedom to operate search, to see what's out there, to help you understand your risk of potential infringement. And then when it comes to copyright, it's less kind of clear on who owns each part of your outputs, and whether that there's anything that you necessarily have to worry about in each piece of content you generate. I think it can differ based on whether you use your own system or ChatGPT or the paid version of ChatGPT. There are those terms about this as well. So it's hard to give a kind of general pointer there.
Yeah.
But I would say, don't just think carte blanche because I prompted it, I own it, and that's it. It's not that simple. So I just suggest, bit of carefulness, but at the same time, you do see a lot of patent attorneys themselves generating AI images and posting it for their LinkedIn articles to discuss the outputs and things. So it's a case by case basis, really, I would say.
Yeah, yeah. And yeah, I think it's that's something we've seen like kind of crop up a few times, you know what I mean? Like, can I, do I own this prompt and therefore the outputs of this prompt? And yeah, it feels like every week there's a new challenge in the sort of intellectual property realm that is kind of based around AI. And Yeah, definitely. Yeah, like you said, like act with caution and with care. And again, I will just add, engage an expert if you're going to be trying to like use this in any sort of commercial way. Um, so Lindsay, just to kind of round off before we move on to our audience Q&A, and please do share some more questions. Don't be shy. We see we've got one in the chat, but we could always do with a few more. But yeah, Lindsay, just going back to kind of what we were kind of talking about earlier about actually the intersection of data protection regulations and GDPR with with AI technology development. Can you elaborate on that intersection and also give us a sense of how businesses can ensure that they remain on the right side of compliance, particularly when resources might be an issue, because we hear that a lot.
Yeah, definitely. It's interesting because the Bank of England did a big survey in terms of what people thought was the key blocker for the rollout of AI tech in their businesses. And that sort of uncertainty from a data protection perspective was raised as one of the key number one blockers. And I think that's because, well, data is the fuel, isn't it, for an AI system? So in some respects, there's a bit of a tension because you need vast amount of data for the training phase for it to work. And then also there's such broad range of applications, so it almost has that human-like intelligence, which is only improving and improving with each version. So I think the good news actually on that front though is that our regulator in the UK, the ICO, has issued some very helpful and very practical guidance on this. And so you really can start to see how you could navigate it. And I'd say some of the key sort of overlaps between well, actually, first of all, I think it's really helpful to remember that the AI Act itself in the EU, it doesn't create like a new data right per se. It's very much feeding back to existing principles of GDPR. So that's a bit of a sigh of relief because if you already have really good processes in place for GDPR, you can just make some minor adjustments, and then that should give you that confidence. If you don't, then obviously that's going to make things a lot more difficult. And people have been realizing that they didn't have good governance, like good data labeling at the start. So actually, there's been a bit of a learning curve. But in terms of what the overlap are and the key themes that are coming out of, for example, the white paper, the Act, and GDPR, a lot of it is really around transparency. So the big bulk of requirements is making sure that people understand that they're interacting with an AI system, for example, for certain things that are categorized as that in the Act. So do you know that you are speaking not to a human agent, but to an AI chatbot? And the banks have done a really good job at this. So if anyone's wanting to, like, is in the developer space and wants to have a look, they're really good at being clear as to when you're sort of skipping from the computer says no into a human agent. So that sort of thing. And then also, if the output has been generated by AI, there's certain requirements around that, sort of label it as such. I think the other one, so transparency, the other one is around making sure that the data you use. So we've already got this inherent concept within GDPR of making sure that the data is relevant, up to date, accurate. That's just slightly nuanced, isn't it, in the context of AI? So it's making sure that what you use to train the system is relevant and sufficiently representative. And that sounds simple in practice, but is actually very, very difficult. And we've seen that go wrong quite a few times in the press, particularly with the big hyperscaler company that you might be familiar with. So even when they tried to make their recruitment tool representative by, stripping out the key identifiers as to whether it was a female or a male, the tool was so smart that it could work out, well, actually, female tend to play hockey and males tend to do rugby or football. So they still were able to work out when it was a female application and disregard that. So they ended up sort of dropping that altogether. So the new kid on the block is sort of synthetic data, which is definitely getting a lot of attention with companies that I work with. And so Again, the ICO's guidance is quite helpful there, because they've said if you're doing a certain processing activity to check that you have a representative data set, and you're taking steps to mitigate, because you'll probably never be able to completely remove bias, that's okay. You can sort of have a lawful basis for doing that, as long as it's, you've got your safeguards in place. So there's quite a few helpful things around that. But I think the main thing where I would love our government to come out and give some really clear guidance is that people aren't aligned on whether the actual AI system, like the model itself, so if the LLM is actually storing personal data or not, which makes it really difficult for people to then contextualize how do we deal with a data subject access request, which is the bane of one's life because it's so time consuming, it's so expensive. And we had a German, of all regulators, the sort of Hamburg DPA, issued a really good opinion paper that said, no, it doesn't. It's not possible to do that because it's tokens, it's numerical numbers, it's not personal data, the model. And we were all, ideally anyway, aligned with that because that made sense. And then actually the sort of EDPB came out and said, oh, well, it might be on a case-by-case basis. You sort of have to look at whether you could regurgitate and then link it back to someone. And it's that sort of uncertainty that is just really difficult for people to then navigate, because they've set the bar so high as to when it would be considered anonymous. So it would be great if the UK government, if they did anything, if they sort of came out and aligned more closely with the Hamburg DPA, because then you could almost have like a ring-fenced data set that people feel quite comfortable using in the UK. But yeah, so that's a bit unclear. But what we do know, and where we do have really good guidance from both the ICO and actually the French data protection regulators, like inputs and outputs very much might contain personal data. And again, just making sure people understand that, because we've seen a lot of policies come out that say, never use personal data in your prompts. Also, more to what Jess was saying, never use confidential information. But a lot of people don't even understand what that means. People don't know like how broad those definitions are. So actually, I think that's a key risk mitigant is taking it back to basics. And when you're bringing the staff up to speed, like, do they actually understand that, Linzi Penman, female, whatever my age, you'll be able to work out who I am, where I live, which company I work for. And it's about, could someone be identified rather than are they like just now identifiable? So yeah, so there's a lot of overlap, but to sort of bring that back, it's the transparency element, which we've known for a while, security, which you could have a whole hour on in and of itself, and then actually just what is considered personal data or not, and how do we make sure it's accurate and representative. Those are probably the three key overlaps.
Yeah, no, that's great, and thanks for that kind of detailed discussion. I actually think it brings up a few things that like we talk about quite a lot, which is it's really exciting to talk about AI and implementing AI and things of that nature, but actually like having like a really solid understanding of data and a really like good data governance process, and also like really solid data literacy across your organization as well. It's fundamental before you start kind of looking at how we actually implement AI into the organization, because like you said, it's the fuel that goes into the AI engine. And you could, if you pour sugar in your petrol tank, you might go for a few miles, but your car's going to explode. So like, you want to use that analogy. Anyway, we have a couple of questions, and I'm going to hopefully get through them. I guess we'll do this a bit of a quick fire round because we only have a limited amount of time left. Jess, I'm going to jump over to you with a question from Smira. I hope I pronounced that properly. Who wants to know, how complex is the situation from an intellectual property sort of point of view when you have a combination of open source and AI licensed models when you are kind of creating AI innovations?
So it can be a bit complex because obviously you have to honor the licenses you enter into, and also some open source code can have certain licenses which restrict you from commercial use and from charging for commercial use of that code. So it is something that would be great if you could keep close track of if you're building these models using open source models or other licensed models. It really should be something you keep detailed records of, and you make sure that you're complying with all the kind of license terms that you're basically entering into. So yes, we have known it to be a bit tricky when there are several different bits of code put together, and you have to make sure each fit is compliant. And so yeah, that's something that can be complex, but with the right organization and tracking from the beginning, can be something you can make sure you're complying with. And yeah, it can be done. It just takes.
It can be done.
build some
You heard it. You heard it here first. It can be done. And thanks so much for that, Jess and Lindsay. I'm going to just bounce over to you. We've got a couple of questions from Richard here. You mentioned standards earlier on. And Richard is asking what kind of companies are seeking the ISO 42001 certification, which is obviously the AI management standard. Is it mostly enterprises, SMEs? Are there any particular industries that are engaging with that?
Yeah. So obviously, I probably have a slightly biased view here based on the type of companies that pay daily rates. So, I mean, I don't know if the other people on the call have a view on that, but for me, it has certainly been the bigger organizations that we're seeing do that. Because you've got to go via an accredited organization like BSI, etc., to actually get that. But what I would say is the Lord Mayor has a free course. I'll try and dig it and put it into the chat because they sort of bring you up to skill with the basics, because he was really, really passionate about standards for AI, and he was doing that for the last, I think, 2 years since it was first announced. So he's trying to make it more accessible. So let me try and dig that out. But from what I see, the people who are ahead of the curve are those that are already in regulated industries. So like the life science sector, the financial services sector, the assurance sector, because their mindset is risk mitigation. So they're much more akin to that. But I'd say it's probably going to become as commonplace as like Horizon 27001, which took a while, didn't it? We saw that with cloud. There was a few front runners and then people catch up.
Fantastic. And yeah, we can certainly share that link when we share the recording with folk afterwards. Another one from Richard, and I hope you don't mind, Richard, but I'm maybe gonna tweak your question a wee bit. And Richard's asking like how you see the sort of like responsible AI and the AI governance field reacting to decisions being made in the attitudes in the sort of US government, for example, around AI safety and regulation. But I maybe want to explode that out a wee bit and also include sort of intellectual property in that conversation as well. So Jess, I'll go to you and ask, are you seeing changes in sort of like attitudes or like approaches to sort of intellectual property and like patent applications that are sort of related to a more sort of let's say challenging and very sort of changeable like global environment around AI safety and regulation?
No, actually, we're not seeing, at least in my line of work, not seeing too much changing really in response to that. But in terms of kind of a lot of laws around the EU AI Act and regulation of AI, that often doesn't directly affect the patent system. So what you might be able to get patented pretty straightforwardly might be something difficult to protect or difficult to implement, in accordance with the AI Act. So I think we are pretty much just seeing business as usual, really. We are seeing a boom. We're seeing many more people come to us with AI based ideas and inventions. Everyone's coming to us with app ideas, seeing if they can protect them. But not so much in relation to the kind of political landscape or anything like that.
Yeah, I suppose that's quite warming to hear actually that in this crazy world there are some things that are fixed and constant, and the patent office is one of them. Um, Lindsay, like I'll kind of knock the same question over to yourself, but with a focus more on responsible AI and AI governance, are you seeing a difference in the sort of attitudes around this, particularly around AI safety and regulation, when we look at some of the kind of different approaches to AI and governments across the world?
Yeah, I mean, because obviously we had like the executive order, which didn't very much promote responsible AI adoption. And then I am very conscious that they're much more pro innovation, but I think it's quite a difficult landscape in the States as well, because that's at the sort of federal level, but on a state level, we are very much starting to see quite similar approaches emerging. So actually the type of companies, again, that I'm maybe biased towards are those who have a big presence in California, in New York. So actually they are using, like we did with GDPR, they're using the approach to govern AI sort of consistently where they can, and then only if it allows them to be a bit more forward thinking or use data in a bit more sort of innovative way will they do that. But even we just did a huge global project on monitoring employees, which everyone wants to do at the moment using tech to do that. And it's, before I'd say 5 years ago or so, you would have said, oh, you can do almost whatever you want in the States, but actually it's becoming much more restrictive even there. So I would say people really want to have a benchmark because they want to protect their reputation. And that, the safety and protecting data goes to your reputation rather than just a tick box compliance exercise.
Yeah, and I think that's a great point actually. Like a lot of good practice does come from kind of reputation protection management and like exploring new commercial kind of niches and things like that. There are usually non-altruistic or non-compliance based reasons for doing the right thing.
Exactly.
And yeah, it's great to point that out. Um, and I think actually I'll just try and squeeze one more question in, which is another question from Richard, and who is asking how important is ethics to organisations in comparison to compliance and risk? Do you see this changing? So I think that's just sort of kind of like leading on from what we really kind of saying there. Like, are people and organisations concerned about doing the right thing, or are they doing the thing that they are told is the right thing?
Yeah, I mean, it's an interesting one. There's actually, I cannot remember her name for the life of me, but there was a woman that she's now done loads of tech talks, so she's gone into the stratosphere. And we used to partner with her like 5 years ago or so, where she was really focused on ethics. But she was working with SMEs, so like the Edinburgh University and stuff like that. And she has, as of the last 6 months, just absolutely exploded because I think it is going to become more important. That's probably where the difference between the States and the UK, it becomes a bit more prevalent. That's right. Yeah, it's Olivia. You've got it. And I would listen to her in a heartbeat because she's so well versed and she's been talking about this for so long. And so I would say that more people are starting to bake it in slightly into the like cost benefit analysis. There's going to be an upfront investment. We're going to make sure that people understand the technology. And then there is a bit more coming through in some of the impact assessments that we're doing. It's probably not the number one of the projects that I'm working on anyway, where a lot of it is focusing on cost savings, being more efficient, not losing a competitive advantage, but it's creeping up more and more. That's my experience.
Yeah, no, that's great, and it's good to hear that as well. That's kind of the way things are going. Okay, so we've got 2 minutes left, so I'm going to do this wrap up very quickly. So before we wrap up for today, Jess, what is your one key takeaway for our audience today around kind of the kind of intellectual property and patenting and protecting your AI innovation? What would you tell them?
I would probably advise people not to take IP advice straight from ChatGPT. Um, because people do, quite trust these Gen AI models. And yes, they are amazing and they can help us out in so many ways. But I will say that, there's no substitute for professional legal advice. And also, when it comes to IP, some information is confidential, so you have to be careful about what you put in there.
Yeah.
But yeah, user wise.
Confidentiality is key here. Yeah, absolutely. And Lindsay, same for you. If you've got one key takeaway for our audience, what would you let them know?
Yeah, it's go back to basics, get the data governance right, make sure you're labeling data, make sure your data is accurate and that you understand that, where personal data is going into these models and therefore is in part of the output. The whole landscape of GDPR still applies.
Amazing, yeah, and I would agree, like, get back to basics and just kind of, like, really understand the foundations that you're building your AI adoption journey on, and yeah, absolutely great, and hopefully our audience can take something away from that. So unfortunately, that is all we have time for. We are at 1 o'clock. I feel like we could have talked about this for like quite a while longer, and I'm also sorry if we didn't manage to get to your questions in the chat. We had quite a few coming through, but I'd like to thank both Lindsay and Jess for your time and your wonderful insights today. And I'd also like to thank all of our attendees for joining us and for the great questions that they sent in as well. So thanks very much, guys. Please remember to take a few minutes to complete our playbook survey as well. We'd really love to hear from you about how we can reshape the playbook, and keep your eyes on the Scottish AI Playbook website for future for details of future events as well. So once again, thank you so much, Lindsay. Thank you, Jess. And thanks everybody for attending, and enjoy the rest of your day.